Welcome to our inaugural pop-up event with the Coinbase Institute. I'm your host, Hermine Wong, director of the Coinbase Institute. And our goal is to host these pop-ups in real time as crypto policy events unfold and get quick takes from experts to unpack these issues. For this event, we've invited our first two guests to chat with us about the rulemaking petition process. You may have heard that last week, Coinbase filed a rulemaking petition with the SEC, asking the SEC to develop rules for digital asset securities. So now you may be asking yourself, what is a rulemaking petition? How is it different from a rulemaking? Why would anyone submit one, and how difficult is it? And is anyone successful with these? To dive into this, we've invited two legal experts to chat through these issues with me. First, James Burnham, a partner at Jones Day and formerly with the Department of Justice in the White House counsel's office. And we also have Vic Khanna, a professor at the University of Michigan Law School, whose research interests include corporate and securities law, among many research interests. Welcome to you both, and thank you again for joining me today. I'm going to kick off with my first question for James. Can you go over the very basics about the difference between a rulemaking and a rulemaking petition, and how do they come about?
Yeah, absolutely. So basically, there's a law called the Administrative Procedure Act that lets agencies issue things called rules, and the rules are meant to basically resemble statutes. They're to implement statutes. And so in a normal rulemaking, the agency will put out a proposed rule, and it will ask people to provide comments on the rule, and all the stakeholders will come and they'll say what they think, and the agency will think about it, and there's a lot of rules about how they think about it. And then over time, they'll issue a final rule or not, and the final rule will have a long preamble that explains what they've said about each of these comments. A petition for a rulemaking is basically a mechanism in Section 553 of the 553E of the Administrative Procedure Act, where somebody like Coinbase or another interested party can come and ask the agency to undertake that process in a particular area.
Okay, so now we know the basics of where this rulemaking petition process and the rulemaking process comes from. How hard is it to draft a rulemaking petition, and how frequently do we see them as part of the rulemaking docket?
Vic, do you want to take the first shot on that one?
Well, so it's, by the way, thank you again.
Yes.
It can be challenging to draft these. I mean, it depends on how long they are and what they're addressing. Some of the topics are relatively narrow rule changes or amendments, can be a few pages. Others, such as a Coinbase proposal, addresses the entire sector of digital assets. So those tend to be much more lengthy and much more intricate and can take a great deal of effort to put together.
And how frequently do we see these as part of any agency's rulemaking docket? Is this something that gets triggered a lot, or how does it just come about?
Well, at least for the SEC, I had a quick look. It looks like there's about 10 or 11 per year over the last 15 years. And again, they range from narrow ones to very broad ones. And indeed, usually about once a year, there's a petition by law professors. So of course, we encourage such activity. But they're often dealing with broad topics such as corporate political activities disclosure or ESG, or sometimes they can be very narrow, such as amending a broker rule or something like that. But they're usually about 10 to 11 a year on average, at least in the last 15 or so years.
Yeah, all I would add to that is if you look at the APA, it just says any interested person can submit one of these, which is, as you can imagine, extremely broad. It does say the agencies can limit it to people whose interests are affected, but even that is an extremely broad standard. So you'll see all kinds of things, everything from sort of, kind of crazy, kooky petitions for rulemakings to much more serious documents like the one Coinbase filed last week.
And what is the agency's responsibilities once they receive one of these rulemaking petitions?
Yeah, so I mean, that's a great question. So the APA, the statute that governs all this, I'll keep saying the APA, the Administrative Procedure Act, doesn't impose a lot of concrete obligations on the agency. Basically, it says they have to consider it in a timely fashion and then explain why they did whatever they did at the end of it. I mean, one way to think about it, perhaps, is a petition for a rulemaking is kind of like knocking on the door of the agency and asking them very politely and very kindly to let you into the agency for a nice productive chat. We're all going to talk. And then at the end, maybe you'll engage in something that resembles a a formal rulemaking and will come up with a policy. The other way you can do it is to kick in the door at the agency, and that's something that can kind of happen at the end of the process. So if the agency hears you knocking and slams the door in your face, one thing you can do at the end is sue the agency for arbitrarily denying your petition for a proposed rulemaking. And that's maybe one way to think about two sides of the coin. I don't know if Vic has any thoughts on that.
I mean, that's in broad strokes, that's what you would expect at the SEC. I think under Rule 192A of the SEC's Rules of Practice, that essentially governs this for the SEC. The anticipation, I think, is that the SEC will forward the petition to the staff that is deemed to be relevant. Then after some consideration, they'll produce a recommendation. And then depending on what the recommendation is, a letter will be drafted back to the original petitioner. That sort of lets them know what the staff's recommendation was. Often it is the case that they decide that this is not the right time to go forward with rulemaking, or that there's no need to do rulemaking. Sometimes it might be more, in which case the process might get more elaborated as you go into notice and comment. It's hard to give an exact time frame for when things sort of get responded to, but I think there's a desire to do this in a timely fashion. So often, if they can do it in 6 months, that's a plus.
So this gets to what is considered to be a success with rulemaking petitions. So, if you were to hear back in 6 months, Vic, you're saying that would be huge. That'd be a great plus. James earlier mentioned, hey, this is like a polite knock on the door, and it's possible that the knock on the door will just get a closed door for a long, long time. So what do you think people, when they're submitting these or filing these, are thinking about as a measure of success?
I'll start with at
Sure.
least in the SEC context. You can sometimes get rule changes or rule making started. I think often, though, it's sometimes the case that it's advantageous to just raise the issue and bring it to salience and maybe even make it a more pressing issue. I think a good example in some ways is back in 2011, a group of law professors led by Professor Jackson and Professor Babchuk put forward a rulemaking petition for corporate political activities disclosure. That didn't necessarily result in a rule, but over time, the topic of corporate political activity disclosures has sort of garnered support from many shareholder activists and is commonly something you see in shareholder proposals every year in proxy battles. And I think for the last few years, it's been the number 1 or number 2 issue that you see. So sometimes it's just raising the salience of the issue and bringing it to people's attention to get the ball moving. But if you can get a rule development, that of course is an impressive outcome.
Yeah, I mean, I totally agree. I mean, it really just depends on what your goals are. And so, let's use the Coinbase one as an example, just because it's recent and everybody's familiar with it. The first goal probably was, and has so far been achieved, to get people talking about the issue. And I hope we'll talk about the SEC's bizarre behavior as to digital assets in a minute, because it really is, I don't think, a model of good government. But one objective can be to get people to talk about it. The next objective can be to get them to open the door in a polite way. And Coinbase's petition is as well done to achieve that objective, I think, as anybody could hope for. It's very thorough, very diagnoses the problem well. But then the third can also be to lay the groundwork to, if need be, kick in the door and go in and demand that the agency provide clarity in a vital policy area. And so that's all about building a good record, having a really strong record for why a rulemaking is required, and making it as hard as possible for the agency in a rational, reasoned, persuasive way to refuse to provide regulatory clarity in the area that you're attacking. And so again, I don't know the company's goals on this one, but I think you could say that all three of those are being achieved, at least so far in the process.
Okay, great. And James, you touched upon what else you could talk about here when it comes to the atmospherics of a rulemaking petition. What are your thoughts there? You mentioned it, like, can you share some of those thoughts?
You mean the atmospherics around the SEC?
Yeah.
Yeah. So, I mean, okay. So there's two. Okay. I guess I have two thoughts. I'll give one first. So the first is, I'm sure people on the call or on the video have heard of regulation by enforcement. And with that, it's basically a pejorative term, an appropriately pejorative term, for when a regulatory agency decides that they're going to tell people what the law is by basically randomly prosecuting people under their secret view of what the law actually requires. So one way to think about it is a good government would give everybody very clear rules that people can understand, and then they can obey, and then they can structure their affairs that way. A bad government might keep everything really vague and unclear so that it can punish people for their conduct after the fact, kind of subject to whatever the government secretly thinks the rules are supposed to be. There's an example I like to use: the Roman Emperor Caligula, famously bad emperor, very bad emperor. One of the things he did is he wrote all the laws at the top of a pillar, really, really, really high, where nobody could see any of them. And then he would punish people for breaking these hidden laws at the top of the pillar after the fact. I think agencies should try to stay away from that style of governance. So far, the SEC's approach to digital assets and securities, which is, I would say the most important issue in the entire digital asset economy, has been, more like Caligula and less like what I think should be happening, which is a clear rulemaking of the kind that Coinbase has finally come to them and said, will you please do this, so people understand what the law is.
And James, there's one
Go
thing
ahead.
that sorry, Vic, one thing I probably neglected to, share with our audience is this notice and comment procedure for rulemaking. So I think it'd be helpful if we could give a little background about, you had mentioned earlier how you submit that, but how important is this notice and comment procedure? How important is it to involve the public? And can the public also be involved with a petition for rulemaking?
So yes, it's very, it's very important. One way to think about notice and comment is it's designed to create the platonic ideal of how we imagine Congress operates. Okay, so the idea is you have your sort of expert agency, and then all the stakeholders come and provide thoughtful information, comments, testimony. Well, it's not live testimony, but written comments that then the expert will look at everything, synthesize everything, respond to everything. And out of that, we will get some really well thought out, reasoned rule that then can govern everybody. So it's a super important process. There is a miniature version of that happens with the petition for rulemaking, where the public can submit comments about why the petition for rulemaking should be granted. And if it is granted, then we will have a formal rulemaking in which we'll go through the process again about what the rules should be. So right now we're trying to figure out, should we have rules? I think the answer is pretty obviously yes. And then if the SECs, if we can prevail upon them to agree that rules are a good idea, then we'll have a conversation about what the rules should be. I'm sure Vic has plenty to add on that, though.
Sure. So, I think it's definitely the case that people can add their own comments and thoughts onto the rulemaking petition. Indeed, if you go to the SEC's website that contains a list of many of its rulemaking petitions that it's received, they very frequently do have additional comments by other parties who have expressed their interest in rules being made, or in particular sorts of adjustments to the debate. And I think that, of course, is a useful process to get people discussing an idea, begin to share ideas, get the kind of information in the format that James was talking about, as a way to inform regulatory decision making and make the rules both likely to have greater acceptance, but also to be more informed as a matter of regulatory policy, all of which sounds good.
So what makes possibly, it sounds to me like any member of the public, it could be me, it could be my son, could be my dad, could submit a comment on any rulemaking petition. What makes for a good comment for a rulemaking petition? And is it the same thing that is a good comment for an actual proposal?
Well, I think what makes for a good comment is a unique perspective with some valuable, factual, empirical information that you want that you can convey to the agency, that's not duplicative. So it's not just repeating everything that's in Coinbase's petition, for example, and that's not overly rhetorical and political. Basically, you want to think about it as like a very academic exercise. And so the more you can contribute original information to the process, the more important that's going to be. And by the way, one of the reasons it's important, and this is especially true if they move into an actual rulemaking, is the agency has to respond to comments. So if the agency in a formal rulemaking, it's less so in a petition where it's more abbreviated. But if somebody makes a really good point for why the rule should be X, and the agency says, no, we're going to do Y, they have to respond to that. And if they don't respond to that in a way that makes sense, that's a basis for the court to later invalidate the entire rule. So it's super important.
I agree. I think that the more the comment is factual and based on a well-reasoned analysis or well-reasoned arguments, the better. Sending in a comment in all capital letters is probably not helpful. But generally speaking, a lot of these comments are really well drafted if you read them, and really suggest that people have applied their mind to the issue and are trying to make a helpful contribution.
James, you brought up the idea of like during a notice and comment process, it's important for the agency to respond to comments that it receives. And if not, later on, you'll have the court reviewing it for probably arbitrary and capricious standard under the APA. But for comments received during the rulemaking petition, and petition itself, how much case law is there related to rulemaking petitions?
So there's less. I mean, the agency's burden to decide whether to have the rulemaking is probably lower than its burden to justify a final rule that is actually going to have a direct legal effect in the world. But there are important cases. So there's one very famous case that came out of a petition for a rulemaking called Massachusetts versus EPA. So in 1999, I think, somebody went to the EPA and said, we want you to do a rulemaking on greenhouse gas emissions. We think you should be doing something about greenhouse gas emissions, right? A lot of people think that. Fast forward a few years, the EPA says, no, we don't have any authority over greenhouse gas emissions. And then they got sued by Massachusetts and others. And that case went all the way to the US Supreme Court that said, no, you're wrong. You do have authority over greenhouse gas emissions. Now you have to go back, EPA, and come up with a new reason, either a new reason to not engage in the rulemaking, or you have to engage in the rulemaking. So that's just one example of like one of these things actually having a major effect on the law, because it ended up with the Supreme Court deciding that EPA authority was much different than what the agency thought. So these can be very important things, particularly if the petitioner has the resources and the tenacity to see it all the way through.
Vic, can you, in that vein, can you tell me about what you think has been the most successful kinds of rulemaking petitions at the SEC?
Sure. So, I mean, my sense is that the most successful ones are the ones that are the most carefully thought out and brought by people, as James was saying, with the tenacity to see things through. And of course, in that context, we've seen multiple attempts to do things, for example, on the ESG front, on conflict minerals, and on a handful of other issues that, even if they haven't necessarily resulted in rules, have actually resulted in changes in practice that are significant and important and may not have occurred as quickly or in the same way without the rulemaking petition. All basically at a high level to basically say that these petitions can have real world impacts both on the regulatory side and also in terms of how people do things and how practice develops. So their significance should not be underestimated, although the number of them that actually have that success may not be huge, but that's in part due to the tenacity and the well thought out nature of the arguments that are being made.
And all of this discussion is under this niche area of the legal system, the APA, which James gave us a little summary of in the beginning. And recently, there's been Supreme Court cases about the APA. So what are your thoughts about how does that weigh over an agency right now as they are pondering rulemaking petitions? How might that affect their thinking?
So I mean, I have a couple of thoughts on that. So first, I think I would stop thinking about the SEC's authority over digital assets as a securities law question and think about it more as an administrative law question, because I think that's how many courts are going to think about this issue. I mean, in a nutshell, the Supreme Court and some of the lower courts have not been more hostile to the administrative state than at any time since before the New Deal. I mean, they are going to be tougher on agencies like the SEC now than they've been in many, many, many decades. In particular, just last month, there was a major decision called West Virginia versus EPA that formalized a rule the court's been applying in various cases for some time that basically reduces to major policy questions are for Congress, not for agencies. Why is that relevant here? Well, because the securities laws that underlie the SEC's authority were enacted during the Great Depression. And they, I think many would say, obviously do not resolve how to regulate a $2 trillion industry that emerged in, basically the last 15 years. And so the point is that I think the SEC, part of why they are behaving the way they are, suing 3 individuals in Seattle, where they just kind of assert that a number of tokens are digital assets rather than engage in a rulemaking or tangle with a more well-resourced opponent like Coinbase is because they know they're vulnerable, and so they're just trying to kind of nibble at the pie from each side and develop as much momentum as they can. But I do think they're quite vulnerable, and that the legal aggression is ultimately not going to work out for them. Vic, I don't know what you think.
So, I mean, it'll be very interesting to see sort of how this develops, because, one of the cases, of course, involves allegations of insider trading. And if you're trying to bring that as a securities claim, then implicit within that is the argument that the thing that is being traded over is a security, which is, of course, the issue, one of the issues in debate in the rulemaking petition, and also more generally in the crypto community. And I think that's going to be very interesting to sort of see how that plays out. I think another thing to keep in mind, and this is sort of bridging on some things that James mentioned earlier, when you have a lack of regulatory clarity, you have certain kinds of issues that arise. For example, people might be deterred from engaging in certain activity that might otherwise, if there were regulatory clarity, actually be engaged in and be helpful. But at the same time, it may well be the case that if there's lack of clarity, then people that would have been deterred from doing something had there been regulatory clarity would be encouraged to do it because they figure, well, we don't know if this is prohibited or if it's going to be prohibited. So you could imagine that in addition to rule of law concerns, the lack of clarity also is not a very effective way to actually run the purposes of the law. That is, you may have people being over deterred and you may have people being under deterred, both of which can be problematic.
Okay, James, Vic, I think that we're going to start wrapping this up, but I'm going to ask each of you for whether or not you have any sort of last cocktail chatter type things that you'd like to share with our audience about this rulemaking petition.
Well, I personally think it hasn't come a moment too soon, because the current environment is super unsettled. The SEC's approach has clearly been to kind of keep everybody off kilter while they try to pick off the right targets and develop the law as best they can. My own view is that their grand assertions of authority in the space are very, very legally questionable, and now is the right time to force them to have the conversation. So we now started the knocking. Hopefully, maybe at some point, maybe you'll have to start the kicking, and then we'll see what happens. But I think it's about time for it to start happening.
And I would generally agree that this is a good time for these issues to sort of be addressed. I mean, of course, the SEC is a busy agency. It's been doing things on ESG and SPACs and so forth. But there has been a great deal of discussion on crypto and securities, and other jurisdictions are already putting rules in place. The European Union already has its markets in crypto assets regulation at the end of June that's come out. Other countries already taking steps to do so. And there are various states within the US and local municipalities that are engaging on the issue of how to regulate and how to address digital assets. And given the fact that now the SEC is bringing enforcement actions, it seems like all the factors are crystallizing together for this to be a rather good time to work on the issue of how do you think about digital assets, securities, and related matters. Given that other countries are starting on this, this seems like a good moment for the US to want to be a leader in this area, rather than let the vanguard be taken by other places.
Okay, well, James, Vic, again, thank you for those closing thoughts. Really appreciated having you guys come to this inaugural pop-up event, discuss this issue with us, and I look forward to other conversations in the future.
Thanks so much, Hermine.
Thank
Thank you so much.